found this one, and I think it's a good illustration of a couple of main points about zoning. The first one is the pattern of our communities result from the many individual land use decisions that are made over time. They may seem small one at a time, but they add up to the pattern of our community and where things are located. The second is zoning is one of the most widespread land use controls used by local government. What a zoning ordinance says and how it's administered contribute greatly to whether a community will meet its land use goals. Okay, and here is our outline for today's webinar. We're going to start with a little bit of zoning background, then we'll get into how zoning works, the specific relief mechanisms that are incorporated into zoning, zoning nonconformities, appeal of zoning decisions, and then a few resources. So we'd like to start with a poll. It's actually 2 questions. If you could take a minute to fill this out, I'll read the questions. What is your role or position related to zoning? Are you an elected official, a plan commission, or zoning committee member? You might be on the Zoning Board of Adjustment or Appeals, a zoning staff person, someone interested in zoning, or something else. And then if you scroll down on that poll question box, could you tell us how many people are watching from your site? We'll give you just a minute to fill that out. I see lots of people filling it out. Thank you. Okay, so right now we've got most of the people in. Keep adding your answers. It looks like most of the people attending today are either on a plan commission or zoning committee, you're a member, or your zoning staff. We also have people who are on the zoning board, elected officials, interested people, and other. And then if we look down at the numbers, most of you are by yourselves watching this, but we do have some groups as well of 2, 3, 4, and 5. All right. Thank you very much for those results. That's helpful.
Lynn, I just shared the final results, and if people are still seeing it on their screen, they can just go ahead and X out of that to see the full presentation again.
Okay, so we're going to start with the history and purposes of zoning and how zoning fits in with community planning. Our comprehensive plan is the guiding document for a community, and then we have a number of regulatory tools that can be used to implement that comprehensive plan. Those include the zoning ordinance, the subdivision ordinance, and the official map. Another way to think about it is the comprehensive plan is like the horse deciding where you're going to go. And it guides the zoning and the other tools we just talked about. They're like the cart. They're a way to achieve those goals in the comprehensive plan. I'm going to talk a little bit about urban zoning as well as rural zoning, how it got started and how it functions today. In terms of urban zoning, Milwaukee adopted its first zoning ordinance, the first zoning ordinance in Wisconsin, in 1920. And you can see that it separated industrial uses from residential uses and also from commercial uses. So this was back in 1920, a few years after the city of New York had adopted the first zoning ordinance in the US. And then the Milwaukee County zoning ordinance, which was passed a few years later, was meant in part to prevent building construction in low-lying areas that had flooded in the past and actually build parkways along those rivers in order to avoid flooding out houses and businesses in the future. A little bit about rural zoning in Wisconsin. The great forests of northern Wisconsin were reduced to stumps, slash, and bare soil during the cutover that ran from the late 1860s to the 1920s. That slash burned easily, and there were fires that spread over large areas. And the map shown here, the darker colors show the cutover area of Wisconsin. The owners of the cutover land were eager to sell it after they had logged it, and immigrants were eager to come to the US. Many wanted to own their own land. There were brochures prepared by companies and state government talking about the great quality of northern Wisconsin land, and there were staged photos like this trying to convince people to come. These advertisements were convincing, and the settlers did come, but what they found was not what had been promised. The soils in northern Wisconsin didn't lend themselves to agriculture. The growing season was short, the land was rocky, and there were stumps from logging. So one proposed solution for the stumps was to use explosives to blow them out of the ground. And this was considered success compared to digging stumps by hand, unless somebody got hurt. Farming the cutover land was often not successful. Poor agricultural soils and a short growing season made it tough. And northern counties were left with many abandoned farms and a shrinking tax base. Although there were many well-settled compact communities with low per capita costs for highways and education, there were far larger underpopulated areas where schools were small and settlers were few per mile of road, especially in areas that weren't good for farming. So now you'll see how zoning fits in on the urban level first with the city of Milwaukee, and a few years later, that zoning ordinance was upheld by the Wisconsin Supreme Court. Then in 1929, the Wisconsin legislature authorized zoning to regulate uses in rural areas. And a few years later, Oneida County adopted the first comprehensive rural zoning ordinance in the entire United States. After World War II, development pressure increased greatly, and the Wisconsin legislature adopted the Water Resources Act. The Water Resources Act was in response to very rapid shoreland or waterfront development. And as part of the Water Resources Act, local governments were required to administer minimum shoreland and floodplain zoning regulations. By 1998, less than a third of local governments in Wisconsin had a land use plan. So they kind of had the cart, but no horse. They didn't necessarily know where they were headed with their zoning. So in 1999, in response to the survey finding a third of local governments had a plan, Wisconsin adopted the comprehensive planning law, and there was an associated grant program. In 2010, the legislature said zoning has to be consistent with a comprehensive plan. So how does zoning work, and what does it look like across the state? This map gives us an idea. In Wisconsin, the state has authorized local communities to adopt general zoning, also known as comprehensive zoning. Within unincorporated areas, those are the areas outside of incorporated cities and villages, counties may adopt general zoning. County general zoning only applies in areas where towns approve the county zoning ordinance. Towns also have the authority to approve or disapprove subsequent zoning amendments or changes that affect the town. Towns that choose not to participate in county zoning can adopt their own zoning ordinance with county approval, or they can remain unzoned. So for every 5 towns in Wisconsin, there are approximately 3 that participate in county zoning, 1 with its own town zoning, and 1 that is unzoned. So these areas are shown on the map in green if they're involved in county zoning, blue if they have town zoning, and pink if they have no zoning. Counties also administer shoreland, wetland, and floodplain zoning. At the municipal level, the majority of cities and villages have adopted general zoning ordinances. A handful of cities and villages also exercise extraterritorial zoning. This is zoning that applies within 1.5 to 3 miles outside of the municipal boundary. It requires approval from a joint zoning committee that has equal numbers of members from the municipality and the affected towns. So it's a cooperative venture between the cities and villages and the towns. Cities and villages also administer floodplain zoning and may administer shoreline zoning. When we look at a zoning ordinance, it has two parts. It has a zoning map, like shown here, that divides the community into different zoning districts, so to separate the different land uses, such as residential and industrial. A zoning ordinance also has text that starts with what is the purpose of the overall zoning ordinance, as well as the individual zoning ordinances, what land uses are allowed in each district, what are the dimensional standards within each district, such as setbacks, and then requirements related to parking, signage, landscape, and so on, as well as where the legal authority comes from for the community to have different types of zoning and what the procedures are for applying for permits. Within each zoning district, there are three categories of uses. There are permitted uses. These are uses that are listed in the ordinance and allowed by right in all parts of the zoning district. These are granted by the zoning administrator or staff. There are conditional uses that are sometimes allowed. The use, again, has to be listed in the ordinance for that district, and it may be allowed if suited to the location. Depending on the community, they will identify in their ordinance whether conditional uses are decided by the zoning board, the plan commission, or the governing body. And then the third category is prohibited uses. These are uses that are either not listed for the district or are listed as expressly prohibited. In this case, if someone wants that use on a property, they can apply for a rezone or a use variance if it's allowed under that ordinance. For example, in a residential district, this shows permitted, conditional, and prohibited uses. As you can see, permitted uses would include various types of housing. Conditional uses could include bed and breakfasts, parks, small neighborhood businesses, and prohibited uses could include larger businesses, storage units, and industry. This is an example use table that you might find in a zoning ordinance. It can be very helpful if you have property in a given zoning district to be able to look down the column and see what land uses are permitted, conditional uses, or prohibited within the zoning district. I want to note that on May 11th, which is next Wednesday, there will be a webinar. It's labeled the Plan Commission webinar, but it's going to include more detail, a lot more detail about conditional uses as well as rezoning or ordinance amendments. So in addition to general zoning, which we just talked about, there's also overlay zoning. These are special zoning districts that overlay an existing zoning base, and it adds additional provisions to protect a specific resource. And we're going to go through a couple of examples of that. What's shown here on the map is a wellhead protection overlay. So this is additional requirements in order to protect municipal wells. One overlay district is shoreline zoning. It applies near lakes and rivers within 1,000 feet of a lake, pond, or flowage, and within 300 feet or to the edge of the floodplain along rivers and streams. It's required in unincorporated areas in Wisconsin. The purposes of shoreline zoning are to prevent and control water pollution, to protect our lakes and streams, to protect spawning grounds, fish, and other aquatic life, to reserve the shore cover, the trees and shrubs along the shoreline, and to control building sites, placement of structures, and land uses. Here's a little graphic we developed recently showing some of the shoreline zoning standards, such as setbacks from the water, maintaining the trees and shrubs along the shoreline, and limits on hard surfaces and where they can be located. So on the left-hand side, you have an illustration of shoreline zoning, some of the requirements and the effects that it has. And on the right-hand side, no shoreline zoning, which would allow homes to be very close to the water. That has more impact because the runoff can erode the shorelines. Clearly, we have no trees and shrubs there. That also leads to the erosion because there's very little in terms of roots to hold that soil in place. So on the right-hand side, you end up with more runoff, more erosion. That erosion can lead to algae blooms and smothering some of the fish beds down at the bottom of the lake as that soil lands on the fish eggs. Another example of an overlay zone is a wellhead protection ordinance. This is an example from Stevens Point. Counties, cities, villages, and towns all have authority to adopt ordinances to protect groundwater. This comes from Wisconsin statutes. And municipalities can protect the health of their residents and save money by limiting land uses around municipal wells to keep their drinking water safe. So the blue dots are the municipal wells. And then as shown here, there are two zones, Zone A shown in red and Zone B, the larger area shown in black. And they limit land uses in those areas where when rain or melting snow soaks into the ground, it's going to flow to those municipal wells. Floodplain zoning is a third overlay zone. The purposes are to protect property owners and also to protect the emergency service providers that get sent out to rescue people during floods. We know that in Wisconsin, we're seeing more frequent and more intense heavy rainfalls, which are doing more damage to homes, people, and roads. And we have a noticeable uptick in the number of flooding events and the severity of those flooding events. So we have another poll for you. I think Becky will pop up the poll. The question is, what are the key reasons that your community has zoning? What are you trying to accomplish with your zoning? So the options are to protect public health, protect public safety, provide safe drinking water, protect property owners and emergency service providers, protect lakes, streams, and fisheries, property investments, and avoid land use conflicts. So we'll give you a minute to fill that out. So far, I'm seeing some of the leading reasons for having zoning are to avoid land use conflicts, to protect property owners and emergency service providers. And I think Becky has shared the results here so you can see them. So the overall piece that I see is most communities have zoning for a number of reasons. Maybe one of the least common reasons currently is to provide safe drinking water, which if you're a town and you don't have municipal wells, or a county and you don't have municipal wells, that could be the reason. I will say that some counties have wellhead protection ordinances that apply in multiple cities and villages and the land around those. Yes. Okay, thank you.
All right, and go ahead and X that out if it's still showing on your screen.
Okay, so our next section is local government structure for planning and zoning. At the top of the chart, we have the governing body, which might include county board, city council, village board, or town board. The chairperson of the governing body, or if one exists, the county exec, the county administrator, or mayor, is responsible for appointing boards, committees, and commissions, as well as supervising department heads. The light blue positions are elected officials, and they generally have more discretion in their decision making. And the yellow positions are appointed and generally administer the ordinances. In the next few slides, we'll look at each of these bodies and how they interact. So there are three types of local government decisions. You'll see that the legislative decisions have the most discretion, the most flexibility. Those decisions simply have to be reasonable and constitutional, and public participation is encouraged. So elected officials can be talking to their constituents anywhere, anytime about upcoming decisions. Quasi-judicial decisions. These have an intermediate level of discretion or flexibility. They're predetermined standards that apply. They're typically listed in the ordinance or our state statutes. Conditions can be applied. And in this case, because they're quasi-judicial, that means like a judge, discussion only is to happen during the hearing or via letter. If discussion happens outside of a hearing, that should be shared during the hearing. And then administrative or permitted uses amount to applying the ordinance as written. Who makes which decisions related to planning and zoning? So the governing body makes the decisions on plans, ordinances, and amendments. They make those decisions based on recommendations from the Plan Commission or Zoning Committee and technical support from planning and zoning staff. The quasi-judicial decisions, such as variances, are made by zoning boards, administrative appeals, also by the zoning board, and conditional uses, again, it depends on the local community. They can assign these to the governing body, the Plan Commission, or the zoning board in their ordinance. And then administrative decisions, such as permits, come from the planning and zoning staff. Now we'll move on to relief mechanisms. Variances allow a property owner to do something prohibited by the zoning board. Appeals are contested decisions or interpretations of the zoning ordinance and are decided by either the zoning board or circuit court. And map or text amendments, also known as rezones, are changes to the zoning ordinance that are adopted by the governing body. So we'll start with variances. A variance allows a property owner to do something prohibited by the zoning ordinance. It provides relief in limited or unusual circumstances, usually tied to the property, the characteristics of the property. And variances are not meant to provide general ordinance flexibility. There are two types of variance under Wisconsin law. One is area variances that allow the modification of a physical, dimensional, or locational requirement. And the other is use variances, which permit a landowner to put a property to an otherwise prohibited use. Use variances aren't allowed under some ordinances. They can be problematic, and use variances are prohibited under shoreline zoning. For all types of variances, the applicant has the burden of proof to show that these three statutory tests are met. Unnecessary hardship due to conditions unique to the property, and it's not contrary to the public interest, which are the purpose statements listed in the zoning ordinance. For floodplain variances, the applicant, in addition to meeting these three standards, also has to show that they meet an additional 13 standards. On Thursday of this week, on May 5th, we will have a webinar that's specific to zoning boards of adjustment and boards of appeal, and we'll be talking in detail about variances and what each of these three standards mean. And now I think Becky is going to move forward with nonconformities.
Thanks, Lynn. I'm going to wrap up with just a couple of topics, including nonconformities and appeals. So if we could advance the slide. All right, so nonconformities are items that were legally established within your community prior to adopting or amending a zoning ordinance, but they no longer comply with current provisions. And there's really three different categories of nonconformities. These are each spelled out in state statutes. And likewise, I would recommend that you include a section in your local zoning ordinance that addresses how you handle each of these three types of nonconformities. So the first is a nonconforming use. This is a continued use of a building, land, structure, fixture, etc. But the use is not listed or not allowed by the zoning ordinance. So there are protections provided in state statutes for each of these three different types. In the case of nonconforming uses, you actually cannot prohibit this, but if a use is discontinued for 12 months, you can phase this out. Okay, a lot of communities will also require that you cannot extend a nonconforming use, but you can limit repairs or alterations based on 50% of assessed value. The second category of nonconformities are structures. This is where you have a building placed on a lot that does not meet one of the dimensional requirements, like a setback, a height limit, lot coverage, etc. Okay, these you may not prohibit, but you can limit expansion based on cost. And then lastly, nonconforming lots, sometimes known as substandard lots, are lots that don't meet your lot size requirements or dimensional requirements. And then the protection provided in state statutes here is that you cannot require merger of those substandard lots. Just from a big picture perspective, I do recommend towns and counties are required to track nonconformities. I recommend that all municipalities also get a good handle on what sorts of nonconformities exist within your community and track those things, much like you would keep track of variances or conditional uses. And then I also recommend, especially if you're going to be making some major changes to your zoning ordinance, it's quite possible to create non-conforming situations that you may not have intended. In fact, if we look back at our historic downtowns or neighborhoods, a lot of those things would not necessarily be allowed under the current zoning provisions. So it can be a good idea to actually include language in your zoning ordinance to address those and make those things legal and allowed to continue. That comes into play when banks look at lots or structures for financing, and you want to make sure that you're not unnecessarily prohibiting things if that was not your intent. So Lynn, if you could advance to the next slide, we'll move into appeals. All right, so this slide shows how zoning decisions are appealed within a community. I recommend starting at the bottom of this chart, and you can see that decisions of the zoning administrator, such as interpretation of the zoning ordinance, accuracy of measurements, permitted uses that might be granted or denied, those types of decisions are appealed to your zoning board of adjustment or zoning board of appeals. Likewise, decisions of your plan commission or your zoning committee, this could include things like conditional uses, if assigned to the plan commission, can be appealed directly to the zoning board of adjustment or appeals. Decisions of the governing body, typically this would be things like rezones or conditional uses as well, are appealed directly to circuit court. So based upon where you start your conditional uses, a lot of communities will choose to assign that to the plan commission so that they have that second layer of appeal within their local community. Okay, so once things move through the circuit courts, they can be appealed through higher levels of courts. Anything that is taken up by the Wisconsin Supreme Court and decisions of the Court of Appeals that are deemed published are items that essentially create case law, or they create new rules for zoning within the state. So if you've ever taken a look at state statutes, especially related to zoning, there are numerous court cases that are noted within footnotes, and those also become zoning rules for Wisconsin. Then if you could advance one more. Okay. So a couple of important ideas to keep yourselves out of the courts, or at least to defend yourself should you ever make it there. These are 5 important points that you want to be cognizant of and follow, because courts will generally defer to local decision makers if these tests are met. The first is authority. Make sure that you're empowered by statute or ordinance to act on a matter. So in the case of conditional use permits, your local ordinance needs to specify which body has that authority. Second, proper procedures. Did you follow procedures such as providing advance notice, holding open meetings, holding a public hearing when appropriate? We do a lot of in-person workshops around the state, and oftentimes there'll be attorneys who attend those. And the thing I hear from a lot of attorneys is that the easiest way to appeal a decision is not on the decision itself, but on whether or not a local governing body or plan commission or other decision-making body followed the proper procedures. Okay. The third point then is proper standards. Standards can be found in a few different areas depending upon the zoning decision at hand. Your standards might be found in your local zoning ordinance. In some cases, they're also found in state statutes and case law. So make sure when you're making a decision that you refer back to those standards and you list your rationale for why those standards were or were not met. So that brings us to the fourth standard, which is having a rational basis for your decision. You can ask yourself if you were unbiased in decision-making and if a reasonable person could have reached the same conclusion. The test here is really not whether a judge who is reviewing your case would have decided in the same manner, not whether they would have made the same decision, but can they follow your rationale? And that is supported by evidence in the record, which is our fifth point here. So you need to create a record of local zoning decisions. That can be done through meeting minutes, recordings, documentation of your decisions. You're not required to make a written decision, but it is helpful to preserve your information in other ways. So when you're summarizing your decision, make sure you're capturing in your meeting minutes or in some other way how you decided, what the decision criteria were, and your rationale for why those standards were or were not met. All right, Lynn, if you'd like to advance. So just a few concluding thoughts. Lynn spent quite a bit of time at the beginning reflecting on that photo of a community, that aerial photo, and talking about how the pattern of a community is really the result of many individual land use decisions over time. Zoning is one tool that can be used by local governments to also influence what land use patterns look like over time. But there's responsibilities that come with zoning as well. It's not necessarily the easiest or most simple tool to administer. So it falls upon local zoning staff as well as local officials to consistently apply your current rules. It's also really important that you keep a bit of a pulse on your zoning ordinance and you make regular zoning updates so that they continue to reflect what it is that your community is trying to achieve. Especially for small communities in the state that may or may not be served by zoning staff, I highly recommend kind of looking a bit critically at your zoning ordinance and simplifying where you can, matching the complexity of your regulations with the capacity that you actually have to administer those ordinances. And then also keep in mind that zoning is just one tool in your toolbox. It can be used with other land use tools, such as subdivision regulations, your comprehensive plan, financing decisions, et cetera, to help you achieve what you're looking to do in terms of land use within your community. Then could you advance one more? And again, thank you. So we do have a few additional webinars in this series. On Thursday of this week, Lynn will be talking about the role of the Zoning Board of Adjustment, and Zoning Board of Appeals, and taking a deep dive into variances. Next week, I will be talking about the role of the Plan Commission and looking specifically at rezones, those zoning ordinance amendments, as well as conditional uses. And then we're following up with a couple of special topics, shoreline zoning and zoning to protect groundwater. So if you've already registered for this, all of those items are listed in Eventbrite, and you can also go back in and add those topics if you so choose. I want to point you to a couple of resources. You can find these both on our website as well as early on in the webinar, Karen had posted a webinar resource page. So on that page, you're going to find a copy of our Plan Commission Handbook that's shown here. And then if you could advance one more. We also have a zoning board handbook. I recommend that at least one member in your community have access to each of these handbooks that kind of define their roles and responsibilities and take them through important tools like zoning and planning and so forth. In addition to the handbooks, if you prefer to look at things online, we also have a land use training and resources website where you can digest some of this information in smaller bite-sized modules. There are some additional video clips and resources that are associated with that website. So that brings us to the conclusion of our webinar. We do have about 20 minutes reserved for questions. And Lynn, I am hoping that you've been kind of monitoring the chat box as I was presenting here so that we can start to process through some of those questions.
So I'll start with the first one. We've got a mix here, Becky, so I think it's best if we just kind of split them up.
Perfect.
The first one is, what if a zoning ordinance doesn't provide for a zoning board? Who takes on those roles if there is no zoning board? And the short answer is the zoning ordinance needs to be amended, so it includes a zoning board. You can't just hand those decisions off to the governing body, such as the town board, or to the plan commission. And part of the reason for that is because zoning board decisions are all quasi-judicial. People are supposed to act like a judge, be unbiased. And it's difficult to be unbiased if you're also, for instance, on the town board as an elected official, possibly as a plan commission member if you're making recommendations for how to change the ordinance. So there should be a separate zoning board, and that should be described in the zoning ordinance using the statutory language related to zoning boards. The second question is public notification. Our zoning ordinance does not detail individual notification on rezoning or other zoning issues for applicants. The issue is on the notice for the meeting, but is there state statute that requires individual notification for zoning issues, like all those within 300 feet of the property? Do you want to address that one, Becky, or would you like me to?
Why don't you go ahead and start, Lynn, on that one, and I will chime in.
Sure. So there are very clear requirements for public notifications in terms of public notice and publications in newspapers, but in terms of corresponding with individual property owners who live in the area, there aren't state requirements for that. That is up to the local ordinance to decide that. So you can set those distances, or whether it's adjacent property owners, that's up to the local community to decide.
Lynn, one thing I'll add to that is a number of years ago, there was a change to state statutes. I think it's actually found in Chapter 66, but it does require that municipalities maintain a list of property owners who would like to receive notification of zoning changes. So that's something to be aware of as well, so that if the zoning for their property was changed, you're required to provide them with specific notice.
Mm-hmm.
But yeah, I do also recommend providing some clarity in your local ordinance and then consistently following it.
The next question is, we have a Board of Zoning and Housing Appeal, Plan Commission, and Safety and Ordinance Committee. Could the Plan Commission and Safety and Ordinance Committee be combined into one commission? I'm not familiar with a Safety and Ordinance Committee, but if that's, well, you say the Plan Commission below. I think the main piece is similar to the first question, that you need to have separate bodies for the Plan Commission making recommendations on changing the ordinance, compared to the Zoning Board of Appeals, which is that quasi-judicial body deciding whether to provide exceptions to individual property owners. So those two should be separate. It's possible you can combine some of these others with one or the other. For instance, I don't know specifically what the safety committee does or the safety and ordinance committee, but that might be able to be combined with the plan commission.
Yeah, and Lynn, there is authority within statutes to actually assign quite a bit of responsibility to the plan commission, basically anything that the governing body chooses. So I think there certainly is authority that you could do this. But I like Lynn's distinction that you should have a separate zoning board of appeals or zoning board of adjustment that is distinct from your plan commission.
Okay, and then the next question comes from Leanne. It asks, can a municipality increase the distances on shoreland protection? So if you're talking a city or a village, I believe that's possible. If you're talking like ordinary high watermark setbacks, it's not possible at the county level at this point. In 2015, as part of the budget bill, the legislature passed a provision that said counties cannot be more restrictive on shoreline zoning standards. So if you're talking, for instance, like an ordinary high watermark setback, or if you're talking the size of the buffer or vegetation area, counties are not allowed to change those at this point. Towns who had shoreline zoning in place before the county can continue to have those higher standards. Now, if you're talking lot sizes, you can't be more restrictive. A county cannot be more restrictive through shoreline zoning. However, there are different ways to require lot sizes. In addition to shoreline zoning, lot sizes can be required through general zoning and through subdivision ordinances. We had a Wisconsin Supreme Court case last year from Oneida County, town of Newbold, that said that using the subdivision ordinance to require larger frontage measurements or larger lot sizes is allowable. So it's kind of a mixed bag there, depending on what unit of local government you are.
And I'll take the next question from Kathy. So it states, if rezoning an area or district to a classification, I'm assuming she means a use classification, that is not listed in the current edition of a town's comprehensive plan, does the entire or part of the plan have to be reopened and public meetings held to be in compliance? So this speaks to the relationship between a comprehensive plan, which Lynn discusses, kind of that future visionary guiding future document versus a zoning ordinance, which regulates the landscape today. So there is a consistency requirement that if you're making zoning changes, that the plan generally reflect and provides guidance that allows for that type of zoning. So if you're rezoning and creating, first, let's just take the situation where you're rezoning for a new use, then yes, you absolutely do need to hold a public hearing. A rezoning or a zoning amendment does require a public hearing. But as part of that, before you even get to that step, you should also be consulting with your comprehensive plan. And if for some reason the plan provides wildly different guidance than what you are rezoning to, you should also back up a step and amend that comprehensive plan. There is also a public hearing requirement for that. Potentially, you could hold that on the same night. So you can do that at the same time in parallel.
Okay.
Then the next one relates to enforcement. Do you want to take a stab at that one?
I will. You think
The
about it while I'm
challenging one.
answering and then add to whatever I come up with. So the question is, could you please discuss enforcement a little more? Specifically, given the limited discretion administrators or other zoning staff have, what best practices or general recommendations could you briefly share? So like you point out, zoning administrators, zoning staff, their role is to administer the zoning ordinance. There isn't a lot of discretion. I guess I would say a few things. One is that many local governments function in terms of enforcement on a complaint basis. They don't have enough zoning staff to keep an eye on every property all the time. So it depends on what they hear about or what they notice as they're driving around the community, issuing permits, doing site inspections. So that's typically how they find out about violations. Once they find out about a violation, like you say, it's their job to administer the ordinance. There is some discretion when it comes to, well, I guess I would say two things. First, I would say that's part of why we covered the relief mechanisms today, the rezones, the variances, the appeals, because most of the flexibility or discretion is not in the hands of the zoning staff. It's in the hands of the bodies that are deciding on those flexibility mechanisms. The Board of Adjustment or Board of Appeals, the Plan Commission or Zoning Committee, and then the governing body. There is also some discretion in terms of once it's been established that there is a violation, then after that decision has been made, to what extent it's going to be pursued. And that discretion can come from the judge. The judge can find that, yes, you know, there's a violation here, but then the question becomes what to do about that. And that's somewhat a discretion of the judge, and it's somewhat discretion of the zoning staff and how much time and effort they have to put into that.
Lynn, I'll add just a few thoughts to that. I think it's really important, if there is a zoning violation, to document the situation. That could be through photos, it could be through letters to the landowner. Just make sure if you're reaching out, you have clear communication, so you're clearly communicating, you know, what part of the ordinance they're violating, why, when they need to bring this back into compliance. That sounds simple, but it's not. And it's even more difficult for those communities that do not have zoning staff, or that may hire someone on a very part-time basis to do that. And that's why I had made that recommendation earlier, to simplify, figure out what it is that is really important in your zoning ordinance, and focus on compliance with those issues, and simplify in other areas. The other recommendation I would make is, this is oftentimes a place where you can involve your attorney. So your corporation counsel, or maybe somebody that you contract with to provide legal advice to your community. And they can provide guidance, because in some cases they need to step in and assist us with this as well. I can also take the next question. It's a pretty straightforward one. So Evan wrote, the name of our commission is the Planning and Zoning Commission. I've heard that zoning is not supposed to be in the name. Do you know if this is true? There's actually, especially at the county level, there's wide variation in what people call their local bodies. The term Plan Commission is what is referred to in state statutes for cities, villages, and in most cases for towns. And it became much more common and popular following that 2010 consistency requirement with the comprehensive plan. But there's nothing that says you can't change the name or expand the responsibilities of your plan commission. So it's perfectly acceptable and fairly common to include a term like zoning in that name, and that's fine.
Okay, and I think I can take the next two. One is mostly a comment. It says, regarding water quality in rural areas, surrounding agriculture and other land use does affect groundwater quality. This is true. All land uses can affect groundwater quality, and that's part of why we're going to do the session on zoning to protect drinking water, which is usually groundwater in Wisconsin. The slides will be available to download, and Karen has provided the link to those. And there's a question, when you say zoning board, is that short for zoning board of appeals? It is. When I say zoning board, it's either short for zoning board of appeals, which is what cities and villages and some towns have, or zoning board of adjustment, which is what counties have. So when I say zoning board, I mean zoning board of appeals or zoning board of adjustment. Same thing for different bodies. Yep. Our Plan Commission Handbook is 2012 edition. Is there one more recent? No, that is the most recent one. Evan has a question. Whenever we have a proposed rezone, we notify all property owners within a certain distance of the rezone. I know it was just mentioned that state statute requires us to maintain a list of property owners who would like to be notified of a zoning change to their property. Are we covered automatically? Are we covered by automatically sending notices, or do we actually need to come up with a list?
I would say you should probably still come up with a list, and I can provide you with the sample wording that other communities have used to include something on their website to do that. Most likely, the majority of people will not take you up on this. But when you talk about being within a certain distance of a rezone, that implies that only, let's say 6 surrounding property owners might be impacted. But also think about the situation where there could be wholesale changes to your zoning ordinance, where someone is not within a specified distance of that. So it would be good to have that list of individuals that are requesting notification. I don't think it's sufficient to say, we provided that general notice. What statutes is actually looking for here is an ability for someone to sign up and receive notice of that.
Okay, there's a question about when the Plan Commission handbook will be updated.
We do not have a specific answer for that. What we're probably likely going to be doing is carving off pieces, looking at the pieces that are most in need of updates. And that is oftentimes driven by state statutes. So for example, some pretty significant changes to conditional uses. Those are some of the things that we can incorporate and do it chapter by chapter. And then just related to a few questions about the handbooks being in electronic form. Yes, they are on our website in a PDF format. And then there are some resources within the handbooks where there's worksheets and sample forms that communities can use. Those, in addition to the PDF format, those are also provided in Microsoft Word format, so you can take them and modify them for your own community. And then the May 11th webinar, I should confirm that date, but I believe that's the one that's next week, Wednesday. And yes, that will be covering conditional uses in more detail. Well, I think that is bringing us to the end of our questions. Feel free to keep putting some of those in the chat box, but we do also have one final poll question where we're trying to just get a handle on some of our demographics in terms of who's attending. This is a voluntary poll. Results are kept confidential, but it does help us to identify who we're reaching, and it's also a requirement because we receive federal funding. So I'm going to go ahead and launch that poll, and I would appreciate a response if you're still listening. All right, did that finally pop up there, Lynn?
Yes, it did.
Okay, great. I can't do those things and talk at the same time. So we can leave that open. Feel free to answer at your leisure, and we'll also stay on for a few more minutes if you think of additional questions that you'd like to put in the chat box. And I do want to thank everyone for attending. I know I noted early on in the webinar that we had probably close to 130 participants. We still have over 100 that still stuck around through all these questions. So thank you for joining us over your lunch hour. Also feel free to reach out through email or through various means to myself or to Lynn if you have some follow-up questions that you think of after the fact. We also do have that resource page where you can find a copy of the slides, our handbooks, and additional resources.
I would just echo Becky in terms of thank you for joining us, and keep in mind if there are other people in your local government or interested citizens, you will be receiving the link to the recording in the next day or two from Karen. So you're welcome to share that with whoever you think would be interested.
And I see Evan's note that you'd like that sample language to be notified of a zoning change. Send me an email or Lynn an email if you heard of something on the webinar today that you'd like additional resources on. And sometimes there's a, a little delay in responding immediately after a webinar because we do get quite a few requests, but we will respond individually. Well, Lynn, it looks like all those who are